All right. All persons having business before the Honorable Associate Judges, now presiding on the District of Columbia Court of Appeals. Draw near and give your attention. God is the United States and His honorable court. This honorable court is now in session. Please be seated to come to order.
Morning, everyone. Welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's calendar. First case we will hear is number 23 CV 832 and 24 CV 45. Peter Farina versus Janet Keenan Housing Corporation et al. We'll hear first from Mr. Farina.
Thank you and good morning. Peter Farina, appellant pro se. I'd like to request to reserve 5 minutes of my time for rebuttal, please. May it please the court. Thank you for the opportunity to discuss my consolidated appeals arising out of these 2 cases that you just mentioned. I'd like to refer to the first case, the District of Columbia case, as the district's case, and Peter Farina v. Janet Keenan Housing Corporation as my case. As the court knows from reviewing the record, at the heart of these cases is the disposition of the property at 1304 Euclid Street Northwest, known as Victor Howell House. It has been providing desperately needed affordable housing to low-income tenants for over 40 years. I have been a tenant there for 35 of those years, acting as head of household and residence. 23 plus years of that 35, the house has been owned by JKHC, the Keenan Corporation, which is a district-based charitable nonprofit recognized by the IRS as a 501c3 public charity. In this case, this court's decision in Jewel v. Rawlings, should I spell that for any transcription? No.
Not necessary, thank you.
2017 provides a good jumping off place for the issues that arose in these 2 cases. In that decision, this court indicated that a settlement agreement must meet 2 requirements to be enforceable. One is that the settlement agreement must be valid under usual contract rules, and that it be properly court approved. The settlement agreement in the district's case fails, and the court approval fails both those tests. A, it's not valid because 1, the sales contract on which it is premised, that is the sale of the property to a private for-profit buyer at market rate, goes against public policy, specifically rules of charitable trusts that apply to the corporation as indicated by this court's ruling in Family Federation v. Moon, footnote 15, and that those trust rules encompass the rule of cypre. I would also
As
note
kind of
that
a preliminary question in the intervention case, or I guess is in your terminology, the district's case, the trial court concluded that you were not an appropriate person to be raising some of the points that you are trying to raise. And that is the issue, at least a preliminary issue with respect to that appeal. So I wonder if you have a response to that kind of threshold question of whether you're an appropriate person to be raising some of these points.
yes, Your Honor, I was going to get to that, but I'll do it right now. I asserted somewhat, I guess, inartfully on my motion to intervene that I thought I had standing under both the Family Federation, well, particularly under the Family Federation case, because it articulates a number of bases on which standing was found for those particular litigants that are very similar to my own, namely that I was a co-creator of Janet Keenan Housing Corporation as evidenced by the articles of incorporation as an initial board member.
Wait, let's just focus on that one first. So it seems like the logic of that would be that if, I mean, I don't know who founded, I don't pick a company that was founded 40 years ago and assume that the co-founder no longer has no longer has any interest in it, is not, no longer works there, does not have any financial interest in it. Would you say that person, and let's say the business goes on and engages in some kind of a transaction, would you say that that person, because the person was involved in the founding of the entity, would be able to come into court and challenge what the entity was thereafter doing simply as an original founder?
Well, the DC code does state, and I could pull up that citation for you, that a trust for charitable purpose, a trust for charitable purposes, I'm mangling this. A charity may be set up under DC code as a trust, and that the settlor, that is a creator or contributor to that trust, may have, has standing to enforce it.
Can I, you say, I'm with you as it relates to someone who is a contributor to the corpus of the trust, like the assets of the trust. But you also think someone who didn't actually contribute any of the economic value of it, but just was involved in its creation, you would say such a person, because the person was kind of involved at the beginning and the setting it up of it, would have the ability to come in and contest what was done to the trust thereafter?
Well, Your Honor, it sounds like you're raising a kind of a hypothetical as opposed to what actually the facts of this particular matter. I guess I would say in the hypothetical, it depends. But if the person has become so remote to the dealings of the operation, or as like in this case, the disposition of some property that they have no connection to or involvement with, then yes, I guess I would concur that there would be no standing on that particular basis. However, in my case, or cases, these cases, I believe there's more than just the recognition that I was a co-creator, if I may.
Yes, please.
I, with others, deliberately co-created the JKHC to acquire title to the Victor Howell House for the purpose of preserving it, and to accept and use money that it was then paying to the previous owner to use for the maintenance and preservation of the house. Furthermore, I was instrumental with others in acquiring funding from the Enterprise Foundation that in its documents specifically indicated that it was, and I'm going to slightly paraphrase, but roughly quote, to acquire Victor Howell House at 1304 Euclid Street for the purpose of continuing its permanent rental housing for low-income adults. Prior to that, stepping back one step, is the articles of incorporation of the corporation itself, the purpose of which being simply to, quote, preserve and promote affordable housing in the District of Columbia, among other things, but that's the principal purpose.
Can I ask, I mean, one driving force, as I understood it, of the trial court's denial of your motion to intervene is sort of what took you so long? Why have you were familiar with this litigation from the beginning? It had been going on for a while. I don't remember the exact, about a year, if I remember right. And that's when your motion to intervene came, and the judge said, we're not going to gum up the works now. You could have jumped in earlier, but right, I don't know if she ruled that you could have jumped in earlier, but assume that she would have let you jump in earlier. But now it's just too late. This train has gone on for far too long to let a Johnny come lately into the case. So what's wrong with that line of thinking?
Your Honor, as obviously a pro se litigant, I was aware of the litigation. In fact, it was my declaration indicating, among other things, a topo right in this suit that the district was bringing. But I was not a party to or represented by the district, obviously. I was receiving information well into the litigation that through a third party who was also not a party and somewhat remotely involved or knowledgeable of the settlement discussions, that it looked like the district was going to abandon its original intent from its complaint to preserve the house and instead allow it to go to a private buyer for a sum of money far in excess of the corporation's liabilities, thereby violating its bylaw against or acting for profit. So I moved as quick as I could based on somewhat fuzzy information and understanding how settlements agreements work, and threw together what I could based on what knowledge I had at the time. I feel the timing is nonetheless appropriate, even though it might be argued otherwise, because, like in the case of, I think it's Mokhyber v. Davis, journalists came to a court seeking to intervene some 7 years after the case was closed in order to obtain some information. I had no knowledge in my case or in these cases that the settlement agreement was done, let alone approved, which it wasn't. So I moved as quick as I could. I believe I have substantive rights that are being impaired or
And what are those?
the rights.
Yeah, what are the substantive rights that are being impaired by the settlement agreement?
I contend that under trust principles that I have standing to enforce the trust, that is to compel the court to act in such a way that the property is preserved for affordable housing, which it has the legal means to do one way or another, as I understand. Or I have a right under the tenant opportunity to purchase agreement.
Right. So the first one I wouldn't think of as your substantive rights, but that's okay. Just bracket that for a second. Let's talk about your TOPA rights. You mentioned TOPA and TOPA rights in the background of your motion to intervene. It is not exactly highlighted.
I'm sorry.
It is not exactly highlighted. It is not exactly clear. I would not think it would be clear to the court from your pleading that what you're saying is, look, Judge, if you approve the settlement agreement, you've got to take into account my TOPA rights. And I should be able to intervene to advocate for those. Do you think you did that?
Two things, Your Honor. It is true that I did not use the words tenant opportunity of purchase or TOPA in my motion to intervene.
Oh, I actually think you did. I actually think on page 3 you did, but keep going. I think it's in the background section of your motion to intervene.
Okay, I'll accept your reading.
Uh-huh.
Okay, we're number one, it's my understanding that the court is responsible for knowing the law and applying it. And if in fact it does not appear in the motion to intervene, it certainly is alluded to in my declaration that launched the district's case. Second,
I will just, just so, because I'm going to be curious to ask JKHC about this as well. It looks to me like it's your July 30th, 2023 motion to intervene at what you have paginated in Exhibit A as page 39, but it actually looks like it's page 3 toward the bottom. There's a paragraph where you talk about your TOPA rights. Again, I don't think it's incredibly clear, but that is something I'm curious about.
okay.
All right, sorry to interrupt. I was kind of putting them on notice that it might come up with them.
Yes, and all right, so the court has, as I understand it, a duty to be aware of any and all law that may impact or arise or be relevant to this particular disposition of the property. And the other thing is that what emerged in my case was this whole exemption statute, court-approved settlements pursuant to a court-approved settlement. I'm sorry, but I looked up some law, I found some things, but I just did not, was not aware of any possibility that my TOPA rights could be exempted. I mean, I was proceeding on the assumption, as it appears that maybe the district itself, maybe the court itself, that this whole exemption question was not previously well understood or contemplated.
Well, Mr. Farina, let me ask you. Let's assume a scenario where it's been sent back and you now have your TOPA rights and you could do something with it. What do you intend to do with the TOPA rights?
Well, Your Honor, I believe first it is the priority, I would hope, would be just the recognition of a right. Based on the facts, based on the execution of agreement prior to litigation.
But that doesn't help you, does it? You have an insolvent corporation and this thing's going towards foreclosure. So what's the plan? Where would you get some substantial relief?
I've presented evidence to the lower court and in filings in this court of persons willing to back me in my effort to acquire the house if in fact the court finds I have a TOPA right.
So you would intend to form a new nonprofit with essentially the same mission, or?
Correct.
And just to clarify
Matt-
an
Matt
answer you
just
previously
mentioned this.
gave.
I'm sorry.
I said, just to clarify an answer you previously gave, I was very interested in Judge Deal's question, which I'm going to paraphrase down to why so late. Is it a fair executive summary of your answer that you believed your interests were aligned and you moved to intervene when you found out they weren't?
Don't let me forget that question.
So the
but
question was why you waited so long to intervene. And what I gathered from your answer, and I wanted to make sure that I was understanding you correctly, is you believe that your interests in the districts were aligned in terms of keeping the house as it was. And you intervened when you found out through another third party that it appeared the settlement was not aligned with that interest.
Correct, as I hear that.
Okay, thank you.
Letting the house go to a for-profit buyer was not at all why I contacted the Attorney General in the first place, to alert them of this pending sale that apparently was going to proceed without court approval. If I may also say one other thing regarding the TOPA right, is that under the approved settlement, the individual, as far as the record indicates, has themselves no intention of preserving the property for affordable housing. I absolutely want to do that in whatever means that I have at my disposal.
Thank you, Mr. Farina. You're out of time, but we will give you your 5 minutes in rebuttal.
All right, thank you.
How do appellees propose to divide their time?
Yes.
Good morning, may it please the court. My name is Steve Hessler, appellee counsel for the Janet Keenan Housing Corporation. And as between myself and the district, I'd like 10, district would like 5. I'm open to any questions that the court may have. First, I'd like to thank the court for expedited argument for the factors which we've briefed and which the trial court took into account in crafting the two major judgments that bring us here today. The first major point that I'd like to make is that in all respects, the trial court was correct in approving the essentially tripartite agreement amongst the district with court approval and my client for the disposition of this asset. The trial court inquired and was satisfied that there was no other alternative. And in the way that these cases turned out, the trial court did approve the settlement agreement in September of 2023, but then we had 4 full days of contested trial type proceedings where whatever may not have been fully fleshed out by Mr. Farina were actually done so in the context of the TOPA case, which we're calling the second case. And so intervention, my client believes, was properly denied. Your Honor is probably going to, I'm looking at you, Judge Deal, probably going to ask me some questions about the TOPA, whether it was front and center in the first case or not. It was in the second case. But intervention was properly denied because, among other things, the trial court in its analysis of and application of the Cypre doctrine concluded, among other things, as a matter of fact, based on the record, that my client was insolvent. As of January of this year, the court found, and it's not disputed, that the underlying National Capital Bank loan was due to expire. As I
Can I just frame what I think the trial court's analysis is a little differently? The way I see it is the district brings a suit saying you shouldn't be, initially claiming you shouldn't be able to sell this asset because it wouldn't be compatible with your charitable purpose. After long sort of negotiations, you get an order that says, sometimes it says that you're permitted, JKHC is permitted to sell it. At one point it says shall sell, but caveat that this isn't binding on any particular buyer. And what the court's concern seems to be is what's going to happen with the proceeds of that sale and make sure that they go toward affordable housing. The court doesn't seem to care one iota about who the buyer is. Why would the court care? And the district, I'll ask the district in a minute. I don't see why the district cares one iota about who the buyer is. I would think what they care about is that you can sell this, provided the proceeds are used in this particular way to go toward affordable housing. And if that's what they care about, I don't see any justification for stripping Mr. Farina of his TOPA rights. If he can pony up that same money, you'd have to match the offer. He could be held to those same conditions, or JKHC could be held to the same conditions of how they use the proceeds. So, what is the interest of cutting off his TOPA rights? Why wasn't it an abuse of discretion where the trial court didn't even seem to be thinking about that at all?
My answer, Your Honor, in 2 words is exactly but. You're exactly right as far as the trial court's analysis of the need to sell. And as a matter of fact, I think it's paragraph number 15 because I co-authored it. The settlement agreement itself allows for certain, I'll call it transactional flexibility in case the current third-party buyer fails, bails, moves on, or whatever. So there is flexibility in the order itself. The trial court, well,
Could I ask you, I hadn't really focused on the implications of the question Judge Dio asked, but is it right if the settlement order doesn't compel, I guess it approves a sale to someone who isn't Mr. Farina? Is that how you
Correct.
characterize it? And therefore you say that an order that says approves a settlement agreement, which says it's lawful for you to do this, though you are not required to do it, and you could sell to Mr. Farina if he matched, you would say that qualifies as a court-approved sale.
Well, yes, the process by which the settlement agreement with the district was approved qualifies exactly under Jewel as a court-ordered settlement agreement.
Can I ask you though, if imagine that Mr. Farina had more clearly, like unambiguously said in the motion to intervene, imagine he'd intervened timely, sought to intervene timely. So, the district sues and says someone's going to sell this property, and he says, I have potential TOPA rights in this property. I want to come in at the very beginning, and I want to make sure that whatever the disposition of this case is consistent with my TOPA rights. Would you agree that he would have had a right to intervene timely to assert his TOPA rights, potential TOPA rights?
As a naked proposition, yes. However, the concern that the Janet Keenan Housing Corporation had from the time Mr. Farina sought intervention, even to this day, is the manner in which Mr. Farina would try to exercise, air quotes, those rights. And here's what I mean by that. Would he be transferring those rights to some other entity? Hence my reference to the recent Court of Appeals authored by you, Your Honor, Justice Deal, with respect to the limited TOPA right that someone who has the objective factors possessed by Mr. Farina has.
Well, that all could have been, that's not so much an answer to my question. It is, he would have been permitted to intervene, but the trial court would have, in determining the nature and extent of his TOPA rights, have to have taken into account some of the concerns that you're describing. So I get that line of thought. What that would have meant for what a settlement agreement that would have been consistent with his TOPA rights would have been is murky. But my question is just, would he have been permitted to intervene? And I took your answer to be, yes, if he had come in and said, I have TOPA rights, we'll see how they spin out, but I want to intervene and make sure that whatever happens is consistent with my TOPA rights. That's something he should have been heard on had he identified that as the nature of his right and sought to intervene timely.
From a process and procedure standpoint, my answer to your honor's question is yes.
Okay.
However,
And then
I-
I'll
Certainly.
let you get to your however, but let me just first ask this.
I was going to say, I like your word murky.
Right. And you agree that if a trial court had said in response to a timely motion to intervene that it specifically relied on possible implications for Mr. Farina's TOPA rights, the trial court had said, I'm not going to think about TOPA. I'm just going to figure out whether in the lawsuit between the district and JKHC, what a good settlement is. And then I'm going to issue an order, and then that order will extinguish any TOPA rights that Mr. Farina might have had under the exemption for court-approved orders. Would you agree that would not be an appropriate way to proceed? That the trial court would have been required, rather than to say, I'm just going to take this lawsuit and figure it out without regard to TOPA rights, and then when I issue an order, there won't be any left, that a trial court faced with a timely request to intervene to protect TOPA rights would be required to actually make sure that the contract, whatever contract it approves at the end of this litigation would be consistent with whatever Mr. Farina's TOPA rights might be, which might be a tricky question, but do you just agree that TOPA would have had to have been taken into account and that the order would have, whatever order approving a contract of sale would have to have lawfully accommodated whatever TOPA rights exist?
Yes, if the TOPA claim had been made timely, not murky, it would have been reversible error for the trial court either to ignore it or dismiss it without a factual basis or in the absence of reasonable, discretion. But that's not what happened here. And so with the.
Can I just go back to Jewel for a second? Because Jewel, I mean, there was a settlement between Mr. Jewel, who was the holder of the TOPA rights, and I believe it was Miss Rawlings. I could be getting that name wrong. So I mean, it makes a lot of sense that somebody, then Mr. Jewel, he purported to assign his TOPA rights to his mom, Miss Jewel. Makes a lot of sense to say, well, one person as part of a settlement agreement can relinquish their TOPA rights. Okay, makes perfect sense. It doesn't make any sense to me. Maybe you can explain it if you want to defend it. Why parties A and B can go over there and agree to relinquish party C's TOPA rights. Like, why? And if a court order sanctioning that is no different than any other court order that is reversible error for violating TOPA, I would think.
Your Honor,
You know,
we didn't. I'm
Okay,
sorry.
go ahead. No, go ahead. No, what's your reaction?
We did not do that.
Okay,
We, meaning my client, the nonprofit, and the district, settled our lawsuit. And as the district has said in its papers, and as the district stood and said on the record to Judge McKenna, the district had no intention of abridging Mr. Farina's TOPA rights. However, and this is what I find in this arcane TOPA area fascinating. The question is whether or not Mr. Farina got a TOPA right because he has attacked the third-party contract from day one as void. And so anticipating this moment, Your Honor, the point here is that the third-party contract that my client had and still has was, I think, conditional upon approval by the court and the district. And so, as in Jewel, my client and the young lady, whose name is not in the record, contracted to buy this building. And that contract was the subject of litigation with the district. But in the timetable that you've seen in the record here, my client signed the contract with the young lady, the third party. The first step in the TOPA process was complied with was, notice to Mr. Farina, and then the court entered a stay. The trial court entered a stay. And as counsel to the buyer, I did not want to overstep. My client did not want to overstep the bounds of that stay. So all sale efforts, including TOPA, stopped. And so then the legal question becomes, what, if anything, air quotes, vested, as Mr. Farina argues, and as the footnote in Jewel says. So the question is not whether the trial court in its review of these two cases did away with a right that Mr. Farina had. The question is whether he had a right at all. However, given the fact that there was a stay of the TOPA process, and given everything that's been recorded or contained in the record, the trial court, after 4 days of proceedings, concluded that there was a court order which extinguished
Okay.
his rights.
Just one more question, because I don't really get your answer. So let me try it with a different, and tell me what's different about this case than the following scenario. I am a homeowner. I have a tenant. I agree to sell my home to a third-party private purchaser for $1 million. The tenant says, I want my TOPA rights, and the third-party private purchaser sues me to go through with the sale. I'm happy to go through with it, so we quickly settle and say, deal, we settle, $1 million, that's the purchase price. Court says, sounds good, you guys have worked out your agreements, settled. Tenant is out of luck
I think
in that scenario? Yeah.
there's language, I think, in Jewel that says that parties cannot engage in that sort of litigation to cut off somebody's right. That is not what happened.
There is some language like that in Joel that there's sort of like nods and says, well, yeah, you wouldn't want to let stuff like that happen.
But
But I don't know how we're not letting stuff like that happen in this case.
Well, because Mr. Farina did have the opportunity to sit at the table, participate in the litigation, and he blew it. And the court took that into consideration, and it didn't take the court, it took the court September, October, November, 5 or 6 months to get there. So it's not as though in your scenario, the tenant who expressed TOPA rights was completely left out in the dark. And that's the sort of scenario, litigation scenario, and perhaps opportunistic litigation that Jewel and this court need to avoid. That is,
Let me ask you another question, and it may be an appropriate question for the district as well. When you put the settlement together, presumptively, the court was satisfied that Mr. Farina and the other tenants were taken care of, particularly by the area of the settlement that says that, I'm just going to call them VOA for now, even though I know that's the broader national organization, but referring to the local one, would provide housing in their district properties. And Mr. Farina challenges that they don't have any, and as we did our research before the case, I didn't see any district properties represented on their website. How are they going to comply with that piece of the settlement?
so I can answer your question based on what I know as trial counsel and appeal counsel. And I did not go to the VOACC website, but as transactions counsel and having participated in discussions with VOACC, there is specific property in Ward 8 by address. The participating entity whose name appears in the record is Housing Counseling Services, who were involved sort of in the back room on all of this. And so, Your Honor, my real estate answer to your question is not so much whether or not VOACC is record owner of property in the district, because that's not required for the creation and maintenance of affordable housing. The question becomes whether VOACC had affordable housing opportunities in the District of Columbia. And during the September proceeding, when Judge McKenna was grilling both me and the district said yes. So they meaning the district was satisfied that there's a DC VOACC sponsored affordable housing opportunity in DC for the opt-in, opt-out provisions of the agreement.
Mr. Hessler, your time has expired. We will, if you have a sentence that you want to wrap up with.
No, I think the court understands oh, yes, I do. To the extent that the court has received favorably information in my briefs about the underlying problem, the trial court found, this is just 1 minute. Here's my punchline. The financial situation of my client is now worse than it was in January when the trial court made her findings of fact and conclusions of law in these judgments. I can represent to this court, A, the National Capital loan, which was extended to August the 20th, has not been extended. B, the real estate taxes that came due in earlier this year, they're due in March and September. 2 real estate tax payments have not been made. And my rough back of the napkin calculus for the court is there's about $92,000 to NCB with no extension. Taxes, two tax bills of $5,200 each are due, and there's $1,700 in the bank. And I haven't billed this case for a year. Thank you.
Thank you, counsel. We'll hear from the district.
Good morning. May it please the court, Lucy Pittman on behalf of the District of Columbia. The district is here on the intervention case only. I'm happy to call it however the court wants me to call it. And I'll just start as a threshold matter. We put this in the briefing that Mr. Farina's opening brief has forfeited most of the court's reasoning for why intervention was properly denied. The court could certainly affirm on the untimeliness, the lack of pleading, and the adequacy of representation. I'm going to say a quick thing about timeliness, and then I'll answer any of the court's questions. I think timeliness is probably the easiest way to resolve this matter. It is when their trial court has found that a motion to intervene is untimely, that is reviewed for abuse of discretion. And here we have trial court factual findings that there was prejudice to the original parties for the late request to intervene. Those findings have been unchallenged on appeal and control here. And I think that's more than sufficient for the court to affirm on that portion of this consolidated case.
Can I ask you, I got hung up on one aspect of that, which is if question A is whether Mr. Farina has standing to seek to intervene, and question B is, was his motion to do so timely? Do we have to decide the standing question before we decide the merits of the timeliness question, or do you think that we could order those two decisions whichever way we like?
I think you can answer the timeliness question first and do not need to necessarily go to the standing issue. I think here as I think reflected in the briefing, Mr. Farina had an interest sort of in kind of a generic way in which we use that term at the outset of the case and knew about it. And as Judge Deal mentioned, it was about a year after the case was filed that he sought to intervene.
To clarify the nature of my concern, I guess sometimes standing questions are treated as necessarily antecedent to any merits determination. So I
don't
understand there's
think
not a
here,
logical
no.
problem with deciding one rather than the other, but
No,
why do you think?
I don't think this is an Article 3 standing issue. I think this was more of was a cause of action identified in the motion. And so I'm sorry, I didn't pick up on that aspect of your question, but I do think you can answer this simply on the timeliness issue.
And do you agree that if talking now about the intervention case, if Mr. Farina had at the beginning of the lawsuit filed a motion to intervene that said, I have potential TOPA rights here, and I would like to make sure that however this litigation spins out between the district and JKHC, my TOPA rights are honored, so I would like to be in. Do you agree that he would have had a right to be in? He would have had standing to be in if that was the nature of the right he asserted?
I think so. The only caveat I have is the trial court obviously has the ability to say if they think that might sort of affect judicial economy in some way if you have too many things, but
he would have had standing. The trial court might have had grounds independent of standing to say that to deny intervention, but you think he would have had standing to try to intervene to assert a potential TOPA right? I
think that's right. I think that's a cause of action that he could have pursued and had that been raised. And I'll just quickly note that Judge Deal did point out on page 3 of the motion to intervene, there is a reference to TOPA. I have always read that particular provision as part of the history of the case. And so it's referring to in 2000, when the nonprofit was created and the house was transferred to the nonprofit or purchased by the nonprofit, there's a reference to TOPA. I certainly didn't read, and I don't think the court or the parties read that as him asserting TOPA rights as part of the motion to intervene. I read that as more sort of a history from 24 years ago. but yeah, that's,
I mean, it doesn't take, I take your point. It is definitely not very clear. The counterpoint might be, you know, trial court in the District of Columbia. Anytime a house with tenants is at sale, like should sort of be hip to the TOPA concerns, should be aware of that. So it shouldn't take that much to, you know, flip on that light switch in the trial judge's mind. And when I read this settlement consent order, I don't have a sense that the heart or really any concern of this consent order and settlement agreement is who the buyer is. Does the district care about that?
no, earlier you accurately, I think, reflected that from the district's perspective, it's what happens with the property.
Right.
Particularly at this.
It's about the proceeds. It's about what happens with the tenants. And if
And
this
that's right.
consent order were entered identically, and you know, I will say, I can't quite make out, you know, at times it says the sale is permitted to go through. They may go through with the sale, subject to, you know, the buyer can always walk out and, you know, if it were delayed, they don't need to go through with the sale. So I don't know if this is really a sale pursuant to a court order or a settlement agreement, but maybe. But I do get the sense that if all these terms were in place just for any sale, you know, these are what you do with the proceeds, these are what you do with the tenants, whoever you sell this property to, and that satisfies the court's concerns. And my understanding is that would satisfy the district's concerns.
Yes, I mean, the settlement agreement paragraph 15 does sort of contemplate what if it's a different buyer. So from the district's perspective, the goal here would be to make sure that the individuals who are living in that home have continued housing, and then to make sure that any of the proceeds after liabilities are paid with regard to the nonprofit. We also have an interest in making sure the nonprofit pays its liabilities. So,
Right.
you know, we have a few interests in this.
I mean, that could be
but-
a reason why you have an interest in, you know, no further delay. TOPA could slow this train down, and right now we've got a solvent JKHC, and if we let this sale go through right now, they're going to pay off their liabilities. They've got some money to rehouse people, and if you let Mr. Farina step in late, all that can go away. These liabilities are stacking up, and that money can dry up, and they could just lose it in a foreclosure sale.
Certainly, and it's as though you read my mind. That was going to be my next
Mhm.
caveat, which is that, to the extent, and it's never good to try to read the tea leaves, but to the extent that this is being remanded on TOPA, the district, while not a party to the TOPA matter, would ask that that everything be done as quickly as possible. And so if the court could be very specific on what questions have to be addressed by the trial court and the parties, and ask that it be done as expedited as possible, keeping in mind TOPA has statutory deadlines. I'm not suggesting that those be altered in any way, but to the extent that the parties can move quickly, because those are real risks. Right now, we're talking about, you know, if this were to go to foreclosure, I don't know how much money would be left to support those 4 residents and for nonprofit going forward. And so that definitely is a concern.
So, Ms. Pittman, glad to be talking to you too. So with those statutory deadlines and everything, just hypothetically, if Mr. Farina had been given TOPA rights and the opportunity to match back a year ago when the settlement was approved, will we still be here today?
I don't know. We didn't take a position on TOPA, so I'm really reluctant to go too far into the TOPA issue here. But as I answered earlier, I think had TOPA been raised at the outset, I think intervention would have been very likely. And I don't know sort of what would have happened. It's hard for me to predict what would have happened in that circumstance. So I'm sorry, I don't have a full answer for you.
Sure.
Unless there's any other questions, the district asks that the court affirm the denial of the motion to intervene.
Thank you. Mr. Farina, we'll hear now from you in rebuttal. You have your 5 minutes that you reserved.
Thank you. That was quite a lot of time, just noting for the record. I think it sounds like the solvency of the corporation is a major concern of the court, certainly of the litigants. I would simply state that with my discussions and with my potential backer, my actual backer, we can resolve this very quickly if the court finds that I do have a right to purchase I would also like to argue just very few seconds that while I certainly advocate for a finding at the very least of a TOPA right in this matter, I do feel that I more than met the qualifications of special interest standing that Mary Hooker had in the Hooker v. Eads home case, being that she never lived at the Eads home, whereas I reside and have contributed substantially the funding, much like the Japanese church did in the Family Federation case, to the corporation. What else? Regarding, okay, I think this is interesting, is that JKHC clearly in its most recent filing, and actually for the first time in these matters, argued that the sales contract itself is not valid. Apparently as a way to argue that the court should disregard any potential vested right in that. But we do have on record that I and JKHC have argued that the sales contract is invalid. Now, of course, if it goes back, it just throws the whole solvency thing into even more precarious situation. But here's another point, is that I'm not aware of any law, and I did not hear the court below, though concerned about the solvency, that in and of itself is grounds for overriding rights I may have either under trust or TOPA or remedies under either of those. Yes, it would be unfortunate if the bank forecloses, but if that's not the worst case scenario as I see it. The worst case is it goes to the private buyer and I have no right to match. So clearly the bank would probably try to get rid of it at a much lower rate than market rate, but that's just speculation. It was incorrect of counsel for corporate of nonprofit to indicate that there was a stay of TOPA when the court originally entered its stay of the sales activity for the purpose of litigation. The corporation's own expert witness, Terrence Lanny of DHCD, the TOPA administrator, indicated that absent a specific stay of TOPA, that process was to proceed in parallel with the litigation.
But it didn't. You could have said, hey, we're in the negotiation period, court enforced this, but you also just sat back for the year.
I'm sorry.
I don't understand where that point gets you. So maybe you had rights under TOPA that ran contemporaneously with the litigation, but you never asserted them.
Well, I guess that goes to my point that the corporation was, and its counsel certainly was well aware of the TOPA process. They even started that process prior to the district's lawsuit, but chose unilaterally not to continue it by issuing the notice of sale, the Form 3A that would have indicated the contract price and other details. But again, Your Honor, as much as I wish I could know more law or all of the law, I went with my understanding that I did not expect, even if the sale was approved, that I would potentially lose my TOPA rights, or that it would even become an issue. And just to be clear, as the court's well aware of its own footnote 4 in Jewel, my TOPA rights vested with the execution of the contract itself, and which was way before the settlement, and as I argue, is not subject to the court's the TOPA exemption statute. The lower court did note that this court's observation in Jewel that there's no time when a court order has to be entered, but it is also true that the statute does not indicate that contracts executed prior to settlements or court orders approving settlements are exemptable. As for the property in Ward 8, that is not owned by the Volunteers of America. It may have some business there involved in its behavioral health services that I believe it provides the district, but there's no indication that while the money, if it was allowed, may assist relocation, that money would be used to actually preserve that site for permanent affordable housing, which is why the corporation and how the corporation, the requirement that the corporation obtain the property in the first place under the enterprise loan. And let me see, what else? I think what's also dispositive here with regard to the TOPA claim and the trust claim as well, but I'll focus on the TOPA, is that, as I said earlier, the court has a duty to know the law and apply it appropriately, but the parties themselves, particularly with TOPA, were well aware that that issue was active, relevant, and if not under Rule 24A, a matter of right to intervene, that the court would recognize and did not. Specifically, it went to the other parts of that rule. Under Rule 19, the parties are obligated to join an interested party and failed to do so. So I think I will just close by saying that I ask the court to reverse the orders below, find that I have standing under trust rules and or TOPA, and remained the matters back for further proceeding.
Thank you,
No
Mr.
other
Farina.
questions.
Thank you to counsel. The case will now be submitted.
Thank you.
We'll now call the second case on this morning's calendar, Clifton A. Brown versus United States, number 23 CF 455. Whenever you're ready to proceed, counsel.
Good morning, Sean Day on behalf of Clifton Brown. May it please the court. I'd like to reserve 2 minutes for rebuttal. So somewhat surprising to me, this is a matter of first impression. Whether a Maryland conviction for misdemeanor assault can be used for impeachment in the district. And a mechanical reading of DC Code 14-305, enacted as part of an act in 1970, it can, but our argument is that the outcome was clearly not intended by Congress, and or the outcome is absurd or plainly unjust. And really here, the impeachment use of the convictions for misdemeanor assault, it's propensity evidence, and this is just a backdoor way to get that in. Courts in Maryland and the district have agreed that conviction for misdemeanor assault does not involve dishonesty. And the government here has never suggested, they didn't suggest in the trial court that somehow these convictions had bearing on honesty. They have not argued it here. Their argument is simply, the statute says we can do it.
Counsel, since you brought up the propensity evidence point, I thought that was interesting and I looked for it below. Is there anyone in particular you could point out where it was where that argument was preserved, aside from the piece with the request for a limiting jury instruction should Mr. Brown testify?
No, I would just say the propensity argument is implied. The government didn't make the argument below that it had any bearing on honesty. They don't make the argument here. I think rationally, you look at it, it's the courts have decided in Maryland and DC that it has no bearing on honesty. So why are they using it?
You're not, I mean, the statute, part, you know, 14305 B1 A is not at all about honesty. B is about honesty, and for misdemeanors, it needs to be about honesty or a false statement. But for A, it's just, is it punishable for more than a year? So you're not, are you challenging the lawfulness of that provision because you think it's not a reasonable statutory determination to allow people to be impeached on credibility grounds simply because something is a felony, speaking loosely, is punishable by more than a year?
Well, no, I think there are two categories. There's one that the seriousness of the offense could be assault with a deadly weapon. You could argue maybe that doesn't bear on honesty, but there's been a policy decision that that's a serious felony. These are serious crimes.
And just to be clear, you're not challenging that policy decision as unconstitutional or
I am not.
or that you shouldn't read the statute to reflect that as it relates to, at least generally, to felony conviction.
I'm not. What I'm arguing here is it really doesn't fit logically in either category. It's not a felony. It's not a serious crime. And in fact, to point out, to
Well, why
highlight
is it? I mean, it is a felony the way the legislature defined a felony by sort of delegating to state whatever the other state is and saying, we're going to call it a felony for purposes of this statute, or in any event, they didn't use the word felony, but they say you're going to be able to impeach somebody with this conviction as long as the state that entered the conviction punishes that offense by more than a year. So it, again, as you acknowledge, the sort of the plain language of A covers this situation.
there was a one size fits all statement in the statute that would apply to all 50 states. It's not like they looked at all the statutes in all the states and decided that this is what we want to do. And at the time, there was a statute applicable to the DC that specifically defined a felony as anything with a penalty of 1 year, or actually of more than 1 year. But here we just have a unique situation. We have a Maryland statute, a sister state. We've got people commonly crossing the border between Maryland and DC. And this is a situation that's going to commonly come up, but you have this crime. There's no dispute that it's no different than DC crime for simple assault. And in fact, Mr. Brown had a 2018 simple assault conviction in DC that could not be used. You would
I
think
mean, I 100% get your point that it seems kind of anomalous. So I get the thrust of your point, but it seems like rather than being unique, it seems like it was an entirely predictable and foreseeable anomaly. I mean, the district didn't say, as statutes in this general area sometimes do, any offense that we would treat as a felony. They said, whatever other, if the state court that entered, or the court, state or federal, that entered the conviction treats it as, I can use the word felony as a loose description of punishable by more than a year. If they treat it that way, we're going to kind of piggyback on whatever they determine. And if you do that, a legislature that does that would naturally understand that since jurisdictions around the country make lots of different choices about what they punish for more than a year or less than a year, that means that you're going to treat as impeachable some convictions when entered in jurisdiction A that wouldn't be impeachable. The exact same offense wouldn't be impeachable in jurisdiction B or even DC because they punish them differently. So rather than being unique, it seems like it's kind of an obvious feature of the choice they made, which was to just kind of take as a given whatever the other jurisdiction does, even if it is the exact offense and the jurisdiction just chooses to punish it differently.
Except I would say the House Committee report specifically referred to misdemeanor assaults and crimes of passion and their intention that those crimes would not be impeachable. So I would say that it's not an outcome they intended. If they had specifically considered it, the House Committee report suggests that it's something they would have.
So would your argument be different if this wasn't assault and instead it was some other offense that is a misdemeanor not going to dishonesty or false statements in the district, and some other jurisdiction punishes it by more than a year, and just to make it exactly the same as this, and that jurisdiction also doesn't treat it as an impeachable offense for purposes of its own laws of impeachment? Or is your issue really, it's all about assault and all the other anomalies you would apply plain language, but you think that the legislative history tips the balance, or is your point broader?
I think one can make the argument for any other crime that fits this definition that it's either absurd or plainly unjust. But my argument here is certainly bolstered by the legislative history in the House Committee report, which specifically referenced assault and said, we're not going after, this isn't what we mean. This is not an this is a crime of passion. This is not an impeachable offense if it's a simple misdemeanor assault. And
So why didn't that make it into the statute itself? And that kind of, two things you said kind of beg the question for me. If they were aware of it, then why isn't it not a deliberate disinclusion? And then also, you know, this is a sister state. Not only is it a sister state, it's the sister state that Congress elected to have us inherit the common law of and many other things with. Why shouldn't we presume that they're aware, and why wouldn't that counsel against what you're asking us to look at and going beyond the plain language to find this absurdity or go into the legislative history?
well, if I'm not mistaken, I think this was a congressional act in 1970. But yeah, I don't know. This was 1970. I really can't say there's anything else in the legislative history. But I would say there's certainly the clear statement in the committee report that this isn't what they contemplated.
Well,
It
Your
missed-
your opponent argues that the committee report is not as clear as you're suggesting. The language indicates that the intent of the statute was excluding offenses that are primarily those of passion and short temper, such as assault. So primarily seems to be a less than categorical term. And then your opponents rely on other language, which says, but we also think that impeachment should be allowed for any felony. So they may not have contemplated, I guess, that there would be something that was at least, I mean, some forms of assault. If you're thinking of like assault with intent to kill would be impeachable in DC, and Congress, we assume, would have known and intended that. You would agree with that?
For a more serious crime, yes.
So it seems as though Congress may have assumed that at least simple assaults wouldn't have been punishable. It wouldn't have been a punishable, impeachable under DC law or probably under federal law. But they were pretty categorical, saying proof of any prior felony conviction, impeachment, yes. So why is the legislative history so unambiguously clear that a form of assault that is not aggravated by its elements, but that the jurisdiction that imposed the conviction treats as a felony if you're using felony to be defined as punishes by more than a year? Why is it so clear that Congress didn't intend to reach that?
Well, I believe they used crimes of passion, short temper, such as assault. And that's from quoting Williams versus United States 337, a second 772. But I believe it was a reference to assault.
Definitely, but there's the later statement that just says categorically, if it's a felony, impeach away. So it seems like the legislative history at best points in multiple directions on the topic.
I would not necessarily agree.
Yeah, I mean, and it's a funny line because I mean, there are plenty of felonies that are crimes of short temper. I mean, you see assault with intent to kill, you see voluntary manslaughter, second-degree murders, definitely crimes of short temper, at least some varieties of them. So it can't possibly pull the weight that you want it to pull. I mean, that sometimes those things are going to be impeachable under the plain language of the statute.
Well, I would say this doesn't meet either criteria. This is not a serious offense. This is a misdemeanor assault. It's
I mean, in Maryland, I will grant you that this is an odd statute in Maryland. I've dug into this, I wrote an opinion called Duggar versus United States, where we said this wasn't impeachable. I'm not sure if it was a holding, and I know the parties haven't talked about it, so I'm not going to grill you on that. But we said when it came to ineffective assistance of counsel claim, it was ineffective for defense counsel not to impeach somebody with their second-degree assault conviction from Maryland, with some consideration that they could do that. Now, I don't know. But again, I don't think it was contested in that case, so I don't know if it was a holding. But it's serious in Maryland, I guess, although it's kind of weird. I think the sentences actually don't ever approach 10 years and really rarely ever get over a year. So I'm not sure what Maryland is doing, but so far as the statute is concerned, it's serious in the relevant sense that it's punishable by more than a year. I mean, what more kind of scrutiny should we give to that?
that the underlying conduct is the same that will get you simple assault in DC, which is 180 days.
Yeah, I mean, you can't even be prosecuted for possession of certain drugs in DC. It's not criminalized, and in other states it is. So, you know, like I think like Judge McLeese said, this is not unique. So, you know, maybe, I don't know what the laws are in Mississippi, but you know, let's assume simple possession is punishable of certain narcotics by over a year, that is simply not punishable here. So you think same result in that case?
I think for the most part, probably most jurisdictions are going to hew to the line that if it's more than a year, it's felony. If it's less than a year, it's a misdemeanor. That was the line that was drawn in the district, and it holds mostly true still. I found like 3 statutes in DC where it's called a misdemeanor and it's more than a year. And these are somewhat seldom prosecuted things. One was banking reporting regulations. The other was alcohol business reporting regulations. And there was another one, an environmental regulation, where if it's the second offense, the second offense has a penalty of more than a year, but it's still a misdemeanor.
But I think my
But
question was
I
more,
think it's-
are you advocating for sort of a sweeping proposition that quite atextually, the right way to think about this is, would the crime, if it were committed in DC, be punishable by more than a year? Is that sort of the rule that you would sort of graft onto the statute?
If I were stating a general rule, yes. But I'm just advocating, for my client right here, that the second degree assault.
Because you have a little extra ammo in the legislative history for assault in particular, right?
Yes.
Sure.
Um, The the other thing I would say too is one of the problems we have here is, unlike the federal rule of evidence, federal rule of evidence has a fail-safe in there that says, okay, then they have the same definition, a year or more, then you can use it to impeach. But they have the provision in there that for a criminal defendant, if the prejudice is greater than the probative value, that you can't use it. And we lack that here. And I think that's why we're here, frankly, because it's hard to imagine that if we had that fail-safe in this statute, that we would be here. There would have been a judicial determination. Is this really getting at propensity evidence? And should you be allowed to use it, or is the prejudicial value more than the probative value?
Would this have been more going to prejudice if the Maryland conviction had been assault with intent to kill? Or would it have been equally a propensity form of impeachment on your view?
Well, that's a serious offense.
Understood. I'm just
That-
asking you to the extent.
That would fit under the first prong, certainly.
Understood, but my implicit question being, I guess, do you agree that the statute by its terms, at least with offenses that are serious in whatever way one views them, seems to permit impeachment that isn't really focused on the elements of the crime and how it might relate to credibility or honesty in some obvious way, but instead some more general form of impeachment?
I would say that's correct, yes. Yeah, that there's a prong of this where it's just a serious offense and is deemed impeachable for that reason. And I guess the fact finder, the jury, can give it whatever way they deem appropriate with some sort of limiting instruction. But I think here we don't have either. We don't have a serious offense and it's specifically called a misdemeanor by statute in Maryland. And it clearly equates to the simple assault in Maryland, which is 180 days. And it doesn't make sense that his DC conviction in 2018 can't be used as off limits, but a 2012 and earlier can be used. Thank you.
One more question before we let you go away. Perhaps another I may have heard. So assume we went your way and we agreed on this point. Where do you establish the serious harm here? I get the propensity point, but as I look at the record, your client made a self-defense argument, and it seems like there's a number of things in there, his own credibility, the story changing, et cetera, the fact that he re-engaged after the fight was disengaged, that really kind of counsel against harm in this case. How do you combat that and get us to a point where this matters?
I think there are two issues there. One is whether or not this ruling caused him not to testify. And you certainly had pretrial briefing by the defendant and the government. You had an exhaustive decision by the court. And during the Boyd inquiry, he was told that they could use his prior conviction. So it certainly had to have been weighing on his mind. And while it might have been useful if his attorney had said, hey, he's not testifying because of this. The Supreme Court in Luce said that that would really be an empty proposition, because it's not like the government could say, okay, you know what, we changed our mind, or the court can change our mind. Get up there and testify. It's not enforceable. It's sort of an empty ritual. Now, as far as how it would have helped the case, this is a situation where I think it's similar to Arthur. We have, if you don't have the defendant testify, how can you judge harmlessness? And therefore, I would say it's reversible per se if it impacted his right to testify, because there's, he did make an interview to the police, but it was without the assistance of counsel, was not under oath. And I would say there's certainly plenty of things that one could do with the assistance of counsel to try to mitigate the harm that your case might have. I know there's this other case, Haley. In Haley, there were obvious concerns about whether or not he would have testified otherwise, because there were other convictions they could have used to impeach. And also, there was a police interrogation interview in which he lied, and it was excluded because of a Miranda violation. And so this court commented that, had he testified, they could have brought in this this police interview in which he lied, that they couldn't bring in their case in chief, but they could use it for impeachment. That's a case where it's a little more obvious. But this case, I don't think there's anything that weighs that heavily against him.
I take your point. It's very hard to assess harm when somebody doesn't testify, especially in a self-defense case. I think the jury kind of expects to hear from the defendant. The government makes fairly compelling point, though, which is that they did hear from the defendant. They got a non-cross-examined, unimpeached statement in the police interrogation room, where he sort of laid out his self-defense case in a way that, it's almost a boon. Like that's a really great result for a defendant not to have to take the stand and be cross-examined and get their whole story in person, on video, in front of the jury. Were there things, can you point me to anything concrete, but but that story, omitted, explanations X, Y, Z, it wasn't in person, so it didn't feel compelling, what could you point me to? Just, the government's rebuttal that video was as good as you could have hoped for is not a bad one.
Yeah, I think it was a telephone interview.
A telephone interview, okay.
Right. And I think the problem is, right, there was no cross-examination. This is a police interrogation interview on the phone. I mean, it is the police. They're not trying to create a narrative for Mr. Brown that's favorable in any way to him. They are trying to pin this on him and lead him in a direction. So there's a goal in mind. And I don't think you can compare that to testimony with the assistance of counsel. And as far as what we could point to that would be different. I mean, this is an appeal on the record, and that's why it's very difficult. I don't have.
Sure.
Although
I could, if I submitted an affidavit, that would be outside the record.
Although the line of cases trying to apply loose in various ways seem to raise the idea that a defendant who wanted to preserve that issue could try to address that by making a proffer at trial. Here's what some of the issues we've been discussing could have been clarified, you've acknowledged in one way. If the defense attorney had said, my client intended to testify, but this is deterring him. I understand the point, which I think maybe it was in Justice Brennan's concurrence and loose that that's not that testable. But the separate thing that one could do is also say, and by the way, here's a proffer about what his testimony would have been. So there are ways that one could try to address that difficulty.
I think there was, that was discussed in loose by the Supreme Court, and why they thought that wasn't particularly helpful. Because.
Well, they thought it wasn't adequate to preserve the point. And Justice Brennan didn't so much agree that it categorically was inadequate in our cases, or, a little complicated, but.
I would just say it's not necessary here based upon the precedent that this was a clearly legal issue. There was nothing that was going to happen during the trial or during his testimony that would have changed the trial court's decision on impeachment.
Don't you think the presentation, though, had some effect because things moved to voluntary manslaughter from the more serious charge? So that kind of narrative from the telephone interview seemed to have some impact.
I don't know why the jury decided what it decided, but certainly the goal was a full acquittal, a perfect self-defense, if you will. That was the goal, not a lesser included offense.
Thank you. We'll give you your 2 minutes in rebuttal. We'll hear now from the United States.
Morning, may it please the court. Peter Andrews on behalf of the United States. Mr. Brown failed to preserve his claim related to the impeachment evidence when he did not take the stand and testify at his trial. And even as the court has sort of zeroed in on in the first part of this argument, even if he had preserved the claim, the plain language of the statute is unambiguous that Maryland's second-degree assault, because it's punishable by more than 10 years in prison, could have been used, those convictions could have been used to impeach him if he had taken the stand. The trial court got it right, and this court should affirm Mr. Brown's convictions and sentence. So, starting with the plain language issue, because that seems to be, driving a lot of the court's conversation with Mr. Brown's counsel. I don't think this is a case where it's a mechanical and unfair reading of the statute. The statute is set up in a way where, as was identified in the discussion, you have felonies and you have propensity as the two categories of crimes that can be used to impeach a defendant. Felonies, you can imagine different statutes that measure felonies in different ways, that look at what does a state label it? What does DC label the equivalent crime? What Congress chose here was a rule that looks at the available punishment in the other state. And I haven't heard anything that really makes the government think that that's unfair or unjust in this specific instance.
It actually seems kind of, it seems anomalous in a particular, to me, it seems quite anomalous in the particular instance. And if it's justifiable because it's a practical rule. But what's the logic of saying that the exact same conduct, if it's 6 feet on the DC line, it's not impeachable. 6 feet on the Maryland line, it is impeachable, even though it's not impeachable in Maryland and doesn't really go to credibility in the way contemplated by B. That seems pretty arbitrary considered in isolation. What's the logic? Why would a jury or any reasonable system in isolation put one piece of information in front of the jury in one of those scenarios and not in the other?
I think one thing to flag is that, Maryland second-degree assault is not the exact same offense as DC simple assault. There's certainly some overlap between the two, but the Fourth Circuit, when it's taken a look at Maryland's second-degree assault, has made the point that second-degree assault encompasses several distinct crimes, some of which qualify as violent felonies. For example, there is a case called Harcum. It's an unpublished case at 457 F Appendix 343. I apologize, it's not cited in our briefs. But the assault in Harcum left the victim with a severed tendon and artery. And there's kind of a line of Fourth Circuit cases that, in the kind of modified categorical approach, federal law situation, is looking at Maryland's second-degree assault. And it's coming to the conclusion that actually it does include a level of violent assault that would be a felony and is not included in DC simple assault. And so I think it's a little simplistic to say.
I'm a little, DC's simple assault statute includes murder. You could murder someone and be prosecuted for simple assault. So are you saying that second-degree assault in Maryland is the lowest crime that captures some conduct that would be a felony in DC? Or I'm not quite sure I get your point.
Yeah, so I would frame it as Maryland second-degree assault is the lowest version of assault, and it captures some conduct that would be simple assault in DC, but it also captures conduct that would be assault with SBI in DC.
When you say it, so simple assault in DC captures murder. So right. I'm not sure I get your point about capturing. Do you mean there isn't a first degree? It would be the only charge available, and no greater charge that is more classically a felony would be available for certain grades of assault in Maryland. Is that what you're getting at?
That's right. First degree assault requires a greater level of violence or injury.
But your point doesn't, Your point, as I understand it, about interpreting the statute doesn't turn on this.
No,
Because if I understand your argument, it's just a plain language argument, and even if Maryland had the exact same simple assault statute as DC, it had been construed to have the exact same elements. If Maryland punished it by a year and a day, it would be impeachable on your view under the statute, whereas it would not be in DC. Is that right?
yeah, the
And-
plain language of the statute controls here.
And you don't see that as at least considered in isolation, sort of anomalous? So it's hard to see why you would do that if you just looking at that in isolation.
I think it's not anomalous when you think about in the big picture, how do you write a rule that captures the wide variety of conduct and criminal law that's punished in all the jurisdictions across the United States? You have to have a workable rule that Congress put together. As I said earlier, you can imagine different ways of doing it. In this situation, it looks a little bit anomalous because Maryland is right over the border, and DC, you have I think a slightly anomalous situation generally, where DC is very close on both sides, these two much larger states, DC and Maryland and Virginia. But I don't think that there is anything unjust about using a crime that Maryland has decided can be punished by up to 10 years in prison as shorthand for a felony that can be used to impeach credibility at trial.
Here's a potential way out of the anomaly. I don't think I want to defend it very long, but let me just float it for you.
Sure.
Imagine that what Congress is thinking is, well, the place that it's committed is some reflection on like how serious a law you're willing to violate. So let's say in DC, open possession of marijuana outdoors is a civil fine, $25. I don't know what it is. And you know, if you're smoking it outside, I think that's still some type of problem. I could be wrong. And then in Alabama, it's punishable by 10 years. Now you could say, well, yeah, it's the same conduct, but there's nothing anomalous about using the Alabama conviction for impeachment and not the DC one, because one shows sort of a blatant disregard for a serious criminal law, and the other one shows, you know, only the slightest disregard for the law, you know, willingness to pay a slight fine, and nobody pays attention to that civil penalty anyway. I don't know if that's what Congress was thinking. It doesn't seem like a thing I would be thinking if I were in Congress, but it seems like a defensible way out of the anomaly.
Well, this certainly, that is an interesting thought, not one that I've had.
I don't mean, you don't need to run with it. I mean,
No,
I don't love it either.
I do think there is something. I'm not as convinced as Mr. Brown that this rule doesn't make sense. Whether you're relying on a kind of a justification like that, that's, well, you know, the punishment in a different state goes to the severity of the law or the different way that the other state treats the offense. But I really think that Congress is looking for a workable rule that can be applied in DC. The way that they've chosen to enact the kind of traditional categories that can be used for impeachment, serious felonies, and crimes involving dishonesty. The way that they've implemented that is mechanically through a 1-year bar. And that's no different than a statute like the DC felon in possession statute, which uses the same 1-year bar to prevent someone from using a firearm. I wonder whether kind of a holding that this is anomalous would call that ban into question in the same way.
You know, the line of thinking Judge Deal was expressing works best, I think, in the hypotheticals, one of which Judge Deal mentioned earlier, where the conduct at issue is not even a crime in DC. And you could say, well, you know, if someone engages in conduct in DC engages in conduct in some other state that is a crime and an impeachable one because it's punishable by a year or more, let's say, so it says it doesn't go to dishonesty or false statements. You could look at it and say it's really anomalous. This person did act X. And if the person had done it in DC, it wouldn't have been a crime. Of course, it wouldn't have been impeached. The jury would never have heard about it. But in the other jurisdiction, it's a felony and they did it. And if whatever the rationale is for, the line of thinking depends in part on what the rationale is for allowing impeachment with felonies, or that's a rough description, probably not an ideal one. Offense is punishable by more than a year. But if part of that thinking is the jury should know if someone is willing to engage in serious criminal conduct, whatever that jurisdiction where the person happened to be was willing to engage in serious conduct. I mean, I get that line of thinking, but it does depend on a lot of assumptions or inferences about what it is Congress was doing when it permitted impeachment with offenses that are punishable as serious.
Right. I think one thing to keep in mind, you know, Mr. Brown is not really raising a constitutional or kind of constitutional is probably the best way of framing it. You cannot, this situation just cannot be allowed to stand as a matter of my right to testify. What I really think he is raising is a pure statutory interpretation. Yes, the statute, the plain language of the interpretation, it's a valid statute, but in this circumstance, it leads to an anomalous and unfair result. And I just have not seen or heard anything that overcomes that, even in the somewhat unusual situation that we have here.
So what do you make of the legislative history point that simple assault was referenced and that really narrowly, not beyond any other scenario with any other type of possession law or anything else? Just this simple assault deserves its own carve out. I'm not saying I agree with that point, but how would you address it if we get beyond the plain language somehow?
I think the legislative history doesn't get you anything more than ambiguity. I think it gets you more ambiguity, which is why the plain language is the better way to go. I take the point that there's an idea in the committee report that, well, we're not intending to capture these offenses. But there is also the idea that we're trying to effectuate the traditional category of what's a felony. And of course, that is the dividing line in federal law between felonies and misdemeanors, is 1 year in prison. So I don't think the legislative history gets you anything, any clear answer to this question. And absent, I mean, plain language generally should control. And I think especially absent a clear legislative, hey, we clearly did not intend this very specific unusual result. It's a mistake to rely on legislative history in this instance. If there are no further questions, we ask the judgment of the Superior Court be affirmed.
Thank you, counsel.
Thank you.
Mr. Day, you have 2 minutes for rebuttal.
Thank you. Earlier, I referred to a defendant who had obvious other obstacles to testifying. And I think I said the case Haley, but the case was actually Bailey. The government is correct that the Maryland statute does have another prong, but that's not for the assault statute that deals with if you've caused physical injury to a law enforcement officer, probation officer, firefighter, then they call it a felony. But this is involving just the first prong, and it reads, a person may not commit an assault. And DC statute says whoever unlawfully assaults. These are just the garden variety assaults that we're talking about.
You mean that the judgment of conviction in Brown's, all 5 of them in Maryland, actually specifies which of these subprovisions of the assault statute it was committed under? That we know it's not under the more serious one, or, you know, we sort of should just assume that because nobody's really suggesting it was?
I certainly recall that information being in the sentencing memorandum of the government. One was, I think he had 2 in 2012. One was he was trying to return an item to a store and there was a dispute with the store person. So no, I don't think that these were alleged to have been assaults on law enforcement under the second prong. Also, under the harmlessness question, again, you know, the argument of the government is our case was so strong, there's nothing you could have done. There's no testimony that could have saved your case. But if that's the case, you know, they could have at any time said, you know what, we've presented our case. Perfect time, and our case is so strong, so let's just say we're not going to try to impeach him with these prior convictions for a simple assault. The perfect time to have done that would have been during the Boyd inquiry, when the judge, you know, they've presented their case, they know how their case looks. The judge is telling him, if you testify, these convictions can be used against you. That'd be a perfect time for them to say, you know what, we're going to change that and not risk this conviction. But they didn't do that. So now, of course, they want to say that their case was unbeatable, but they certainly didn't feel that at trial. And that's all I have. Any other questions?
Thank you, counsel.
Okay.
The case is now submitted.
Thank you.
We'll now call the final case on this morning's calendar. It is Lo Lillian Smith versus Celine Finance LP et al., number 23 CV 189. Counsel, you can proceed when ready, and if you, I gather that there may be two people arguing
Yes, there
for appellant, to let me know what division of time you have and who's going to do rebuttal, and maybe if you've allocated issues, what issues you have in mind to discuss.
Absolutely, Your Honor. I was going to address that first of all. So first of all, let me say good morning. Daniel Martin appearing pro bono for appellant Lo Lillian Smith. With me on the briefs and counsel table today is my co-counsel Thomas Landers, who will be handling rebuttal. And I'd like to introduce our client, Ms. Smith, who is here in the courtroom with us today. We really thank the court for the opportunity to present argument today, and I plan on reserving 4 minutes for rebuttal. Your Honors, this case is about whether a sophisticated national mortgage corporation can maintain a ruinously high property interest in Ms. Smith's family home when, upon being presented with a sketchy loan application, it failed to do basic due diligence, recklessly dispersed funds to the client's frauders despite multiple red flags, and then recorded its deed of trust on my client's family home despite being told that the house had been fraudulently obtained. The answer to that question is no. Now, this case has a long, complex procedural history, but in the appeal before you today, we're just dealing with one motion for summary judgment that teed up 3 issues for the Superior Court to rule on. First, was the original fraudulent quitclaim deed void? Second, if merely voidable, should Vizio's notice have been assessed from the time that it chose to disperse funds to the scam artists or the date that it recorded its deed of trust with DC? And third, if from the date of disbursement, would a reasonable inquiry beforehand have revealed the fraud before Vizio dispersed the funds? Now, we believe that on all 3 issues, the Superior Court should have ruled in our client's favor. However, the court skipped the first 2 threshold dispositive issues here and then erroneously ruled against our client on the 3rd. That was error. We therefore ask the court to reverse the entry of summary judgment and remand for further proceedings.
I thought when the trial court granted the motion for reconsideration, I believe this was at a February hearing, he said that what he was doing was granting the motion for reconsideration to the extent that he was abandoning his prior ruling that the deed was void, and concluding instead that it was merely voidable. And so, I mean, I get your point that then later he says something about we need to get to whether or not this was fraud, in fact, a fraud in the inducement, which would seem to be wrapped up with his prior statement. But when he later says, no, I've already held that this is voidable and not void, I could see why you say, well, that wasn't a reasoned ruling. I don't really understand why you think it's not a ruling, though. I mean, he's made it clear that he's saying this is voidable and not void, right?
I don't think that was clear in the previous ruling, Your Honor, because he immediately follows up saying voidable, not void, by turning to the point of we need to figure out if this fraud in the factum, and he grants the motion for discovery. Because what happened in the trial court is when the intervener
I mean, you need discovery even if it's voidable, right?
No, the discovery was specifically on the fraud issue. There would have also been discovery on the inquiry notice issue, but in the context of his discussion in the Superior Court, it was about fraud. But let me take Your Honor's point for a moment and say, okay, sure, the ruling is just, I already ruled that. I'm not going to make a reasoned ruling. We still appealed from the entire entry of summary judgment. And so this fraud issue is squarely before the court today.
Sure.
So even if, yes, the court did actually rule on this and you're holding it wasn't an error, we think it was, but you say it's not, then
No.
the error was ruling that this was voidable, not void.
Well, no,
That
but
was also fair.
Judge Steele was asking questions along the lines I was gonna, which is, I'm not quite sure it's right to say the judge skipped the voidable issue. The judge, in its final ruling, absolutely said, here's my conclusion, voidable, not void. The trial, in your view, the trial court gave an incorrect reason for that, which is I've already decided it. But the trial court clearly unambiguously decided the issue. You just take, and maybe this is sort of terminological, but you seem to take issue with the trial court's reasoning. And so I don't see how the trial court skipped it. It incorrectly, in your view, thought it had decided it. Either way, maybe didn't explain it, in your view, either way, incorrect in its ultimate conclusion. But I just am a little puzzled by describing the trial court as having skipped the issue. But
Yeah, Your Honor. So let me break this down into two parts. So first of all, there's also the question of when to test notice, which there's no way you can read the record to say that the trial court ruled on that. So then going back to the fraud point, our point on the fraud point is that if you raised an issue in court and the court said, I'm going to get to that, you need to have your day in court, and then never gets to it, says, I already ruled on that, you haven't been heard. You haven't heard your day in court. I think for purposes of this court's ruling today, we're in the same place. We need to decide whether it was error to hold void, not voidable. But I don't think it's a reasoned judicial decision-making process to just rule, I already ruled on that when you clearly did not. That doesn't make sense to me under this court's case law. So on this fraud point in particular, we're thinking about the case in terms of three buckets. We have void versus voidable. What kind of fraud was it? We have when do you test notice, which is a legal issue under the DC recording statutes. And then we have inquiry notice is our third bucket. So let me start in the first bucket. When we're talking about fraud in the factum, we're talking about you need to have either the nature or an essential term of the deed transfer that is a fraud. And here we have two key things that we want to point the court to about the content and significance of the deed that was different from what it should have been. This is in the language of Archie, the case that we primarily rely on in our briefs. So the first and most important thing that I want to talk to the court today about is the addendum. Ms. Smith was presented with this promise that she was going to be able to be part of the LLC. And she said, I don't really understand why I need to do this deed transfer for us to go into business together. He lies. He says, well, that's how we need to do it in order to pay your mortgage and your utility bills. And she says, okay, then I need an addendum saying that the house is always going to belong to me and that the deed is going to reflect that interest. That's at appendix 444 in the brief. And it says, the house will always belong to Lillian Smith, who is an active member of SJNF Builders LLC, in which the deed will reflect her ownership. But then when the deed is recorded, this addendum is nowhere to be found. And so that is fraud in the factum right there. The second thing.
Did she ever sign that addendum?
Yes, Your Honor. So there are two addenda, which can make it sort of confusing, but they both appear on the same page. And this is at the same point in the appendix I just cited to. So the one addendum was written by an attorney to try and clear up some lien language, and Ms. Smith refused to sign that. The other addendum is specifically about her concern of, I need you to promise me in writing as part of this deed transfer that the house is always going to belong to me. And that she did sign. They both signed it. So then the second part of the fraud is the identity of SJNF Builders. So she was presented with false articles of organization where it was just Mr. Jefferson and her being listed as the members, when in fact there was different articles of organization that listed Jefferson and Fryer as the members, but excluded her. So the identity of SJNF, something that was deeply important to the transaction, was a key term, went to what was actually going on here. That was also fraudulent. And Your Honors, at this point, I want to point to a case that was not cited by either side in the briefing, but we found it while we were doing our due diligence and just to make sure that we're covering all our ethical bases today. There's a case called Capital River from 2023 when we were writing the briefs. And in that case, the court held that an operating agreement for our LLC that's forged does not forge the deed itself. We don't think that affects any of our analysis today because we're talking about the addendum.
could you give us a cite to that case?
Yes, absolutely, Your Honor. It's 301 A3rd 1234. So it speaks to some of these issues, but we think it's clearly distinguishable. It's not the case of what's going on today. We just wanted to present it to the court.
Thank you, counsel. With respect to this issue, are you asking us to decide the issue as a matter of law in your favor, or is your point narrower and that the trial court either didn't rule on it or was under a misimpression that it already had, or decided incorrectly on summary judgment against you and the matter should be sent back for further proceeding?
Our point is more narrow, that when you're on summary judgment, every reasonable inference needs to be drawn in our client's favor. And when you read every reasonable inference of the facts in our client's favor, you can't grant summary judgment on the fraud question or on the inquiry notice question. So summary judgment should be reversed. This case should be remanded, and we should have a trial on the merits or whatever other further proceedings are appropriate.
Can I ask you about that's the kind of bookends, the middle issue, which is the timing question.
Yes, Your Honor.
As you point out, the trial court doesn't appear to have expressly addressed that question. Is that something that you are asking us to go ahead and decide in the first instance? Or if we were inclined to remand, is that something that we should leave for the trial court to address if necessary on remand?
I think there's lots of different ways that Your Honors could take this case. The salient point for our client is that she should have her day in court. The summary judgment order should be reversed, but you can do it in a couple of different ways. One, you can just remand and you can say, we need answers on these questions before we move forward. You could rule just on inquiry notice, which is the narrowest of the three, and say, actually, summary judgment shouldn't have been granted on inquiry notice. So we're remanding the whole thing because we're reversing summary judgment. Or you could answer some of these legal issues and then remand. And so we're not asking you affirmatively to go out and make rulings in our client's favor. We're just saying summary judgment should not have been granted here, and the case should be remanded. But we think the court has the power to answer those questions if you were so inclined. So turning to that actual notice argument, stepping aside from my first bucket, going to the second, I want to just talk about why we think DC's recording statutes are unique and why this rule would make sense. So the DC code says that normally a deed shall take effect from the date of delivery, except that as to creditors and subsequent bona fide purchasers and others interested in the property.
Well, you're I think skipping a little bit of language there. I mean,
I skipped and mortgagees without notice of said deed. Apologies, Your Honor. Yes. It shall only take effect from the time of its delivery to the recorder of deeds for record. So this
and the key language here is others interested in the property.
Yes, Your Honor.
Right?
Ms. Smith is others interested in the property because if she is the actual correct legal title holder, then she is another interested in the property.
And so I struggled to figure out what that language means or how broad it is. So just to take one hypothetical, if you don't think there's any implicit limit and it's just anybody with an interest in the property, let's imagine I own property and I sign a deed selling it to you and I deliver that deed to you and you don't record it yet. You haven't recorded it yet. Is that deed effective as to me?
Effective as to you? Yes, Your Honor.
Well, why am I not an other interested in the property?
Because you don't
It's not
have
effective until it's been recorded. If
because you don't have an interest in the property vis-a-vis me. The difference in the chain of title here is that we're talking about Vizio via the scam artists to Ms. Smith. And so Ms. Smith, to the extent there's fraud, clearly is interested in the property as relates to Vizio.
So you make the key point that we have to unravel the fraud question to even get to that.
Yeah, yes, Your Honor. I think the logical answer of the questions would be first, was it void or voidable? Second, is it actual notice? Because they knew when they recorded the deed that Ms. Smith was alleging fraud. And then third, inquiry notice.
So give me to the point where you're going to explain how this makes sense. Because I don't think it makes sense. So if Ms. Smith's interest in the property has not changed between October and December, once the bank hands over the money, sort of they can go to court to enforce the deed against the person who conveyed it to them. They have some interest in it. I don't know why I'm looking to the recordation of deed statute. I understand you have a Maryland state case that did that. But why would I look to that deed statute to define when somebody has an interest as a bona fide purchaser? I would think that if I'm asking the relevant question, right, is are they a bona fide purchaser? And you would think that question would be answered by, well, when they hand over the money. Why isn't that the more sensible way of looking at it? I'm putting aside sort of how you would read the statute. I think you're going to tell me why you think it makes sense to read it otherwise.
Yeah, so my answer on why it makes sense is interlinked with the statute, because the statute says you only have 30 days to record. So it's clearly a priority for DC to get recordations done quickly. And this court's case law has always emphasized being able to rely on the record title as a point of priority.
I mean, I get, no, but explain to me why the bank who hands over $500,000 for a house on day one, so they have no inquiry notice, they have no notice of fraud. And then, you know, lollygags a little and waits till day 30 to record the deed, and 15 days in between, they learned that it was, there was a fraudulent conveyance somewhere down the chain of title. I mean, who cares? Who cares for the bona fide? I mean, why would we care about that when we consider whether or not they're a bona fide purchaser? If they had recorded it earlier, they would be. If they recorded it later, they're not. And why on earth would we draw that distinction?
Because that incentivizes people to record their deeds, and the whole system is premised on the recording system working. So, and again, I'm not saying that they would be without a remedy in that situation. They would certainly have a remedy against the people that took out the fraudulent loan against them. And they would also maybe have an equitable remedy against the property itself through some sort of constructive lien. But that would be different than having a valid property interest in the house, which is defined by the
It's a very strict incentive to, I mean, why not just say you have to record it the same day if you want to, you know, or why interpose this sort of random chance that you'll learn about a fraud, even though you, as a bona fide purchaser, handed over the money? I just don't get it. I mean, you could say that's what the statute says, and we should look to the statute. Fine, I can understand those arguments. I'm not sure how thoughtful the Maryland court was in sort of looking toward the deed recordation statute. But I really don't understand why that would be the regime. You know, I can get it for post-sale creditors who, you know, lend money without notice. You know, it makes sense to apply the statute to them. They didn't know that this had a different encumbrance on it, so they should get higher priority if it comes time to collect. I don't get why Ms. Smith would get back in, you know, why the relevant date for whether or not this was a bona fide purchase was December or October. I just don't get it.
Okay, Your Honor. Well, I mean, my answer is really, this is the statutory system.
sure, fine.
And this is what the council has laid out.
Why, the statute says when a deed takes effect. Why does that govern by its terms the definition of when someone is a bona fide purchaser?
So you could conceivably separate those analyses. The reason we think that it defines bona fide purchaser is because of the others interested in the property language. It's when does it take effect as to Ms. Smith. So it wouldn't be taking effect to other people. It's just the three people that are laid out in the statute.
No, I know, but my point is if eventually a deed is recorded, and so it takes effect against various people in some ways, and the question is, okay, but whether was someone a bona fide purchaser at some other time? The statute here doesn't say, and by the way, you know, leaving aside whether it ever went into effect against anybody, this is also our definition of when you become a bona fide purchaser. That seems like a related, but not necessarily identical issue that the statute doesn't by its terms directly dictate.
Perhaps, Your Honor, but the statute does use the word subsequent bona fide purchasers directly as to who we're talking about in this
Well, as to one
category.
subset of who we're talking about.
Yes.
And can I ask you just in trying to figure out what others' interest in the property means, it seems to me potentially relevant to understand what the clause before it means. And I have a question about that. So there's a list of creditors, subsequent bona fide purchasers, and mortgagees.
Mhm.
And then there's the prepositional phrase without notice of said deed.
Mhm.
Do you understand that prepositional phrase to modify all three of those types of entities? Or do you think it modifies only the last?
It only modifies subsequent bona fide purchasers and mortgagees. That's the
So
staples.
you think two of the last three?
Yes, Your Honor. They're in staples, which we cite in the briefs. The court said creditors can be future or subsequent. So that's how the court's already interpreted it.
Well, but you think it modifies subsequent bona fide purchasers? Although in some ways that's circular, because if you had notice of it, you probably wouldn't be a bona fide.
It's perhaps maybe not the most artfully drafted, but yes, we do, because that's what a bona fide purchaser is. I see I'm out of time. If I can turn to inquiry notice briefly before handing over the reins.
More question here, and then please do turn to it, but, you know, assume that all of the facts in your point about at least inquiry notice. We're not there, that this was really a great fraud that was perpetrated. Doesn't that make this really unworkable? And doesn't that put a whole new category of liability on potential bona fide purchasers? I mean, I get your statutory point about it. We encourage recordation, but I also think, and without drawing you too much into it, like going back to our case law from the 1800s, which I found fascinating to try to decipher with a Black's Law dictionary, you know, we seem to not really go in that direction.
I think, Your Honor, the best answer I have is really prompt recordation is the primary goal of this statute as reflected in what we've cited, and this encourages prompt recordation, as well as protecting innocent people like Ms. Smith. So inquiry notice, the point that I really want to make here is under Clay Properties, you have to do a two-step process. You start with what would a reasonable inquiry of ordinary prudence been, and then what would you have learned? And so here are the things that they could have done. They could have checked the foreclosure docket regularly. They would have discovered on August 24th, months before they closed, that Ms. Smith was alleging a foreclosure rescue scam. They could have contacted Ms. Smith to obtain consent for the payoffs, as was suggested to them by multiple of the lenders. They would have learned that she was not consenting and thought she was a member of SJNF, and that she did not think she sold her home. And so these are just some of the basic things they could have done. And if there are no further questions, Your Honor, I'll sit down.
Well, I have one. I mean, that part's easy. What could they have done? I mean, if they were on inquiry notice to, you know, check with Ms. Smith, game over. I don't think the trial court said they couldn't have figured this out through reasonable diligence. I think the trial court said, well, the red flags weren't so bad. So do you want to give me your, you know, your best shot? I mean, I know you have an expert report that lists 8. Do you want to give me your top 1 or 2?
Yeah, absolutely,
What were the
Your
biggest red flags that they should have understood meant there's something wrong here?
Yes, Your Honor. So we would say this is most analogous to the Martinez case that we cite in our briefs that said if you have quitclaim deeds plus long-term continued possession plus multiple unpaid payoffs, you really should be inquiring further about who this person is. And that's exactly what we have here, plus more. We have an incorrect quitclaim deed for 0 consideration, despite the house being worth well over $200,000 at the time.
Can I ask, just interrupt? I haven't read Martinez. What was the procedural posture there? Was that a grant of summary judgment that got reversed? Was that a affirmance of a verdict? Do you know?
Yeah, the trial court in that case granted a directed verdict on this question, and the Supreme Court reversed of Washington.
That was after trial, though.
It was
directed
after,
verdict,
even after trial, yeah. So very similar to what we're dealing with here, yeah. So we have this incorrect quitclaim deed that has $0 in consideration. We have long-term continued possession of the house, even though they only finance rent-ready property. And there's this fictitious tenant, Moses Purnell, that we don't think ever existed. Certainly it's not in the record. And they also had multiple payoffs that we're having an issue with, including the DC Housing Authority that said, we don't understand how we don't have any notice of the sale. This is an abusive way to pay these liens. So that's just my top 3. I've got more if you want me to keep going.
Love it.
All right.
Thank you,
Your
Your
Honor.
Honor. Your 4 minutes rebuttal.
Morning, Your Honors.
Can you also explain how you're dividing your time?
Oh, yes, sir. Counsel for Rushmore only asked for 1 minute, so I may take 14 minutes if I need that much. May it please the court, my name is Richard Lash. I'm counsel for Wilmington Savings Fund, which is one of the appellees in the case. While it's fresh in my mind, Judge Deal, you talked about the fraud and the factum and the trial court's reconsideration of the motion in February 2021 and changed the order from ab initio fraud to fraud in the inducement, so meaning it would be voidable as opposed to void. I think Your Honor was on the exact right tracks. I think the judge did reverse himself. He gave the parties the opportunity to do discovery on, I thought, mostly on the bona fide purchaser issue, because if it's voidable, if you're not a bona fide purchaser, you don't take free of the fraud, and title would remain in Mrs. Smith. But if you read the transcript, it seems to indicate that he gave discovery on all issues. My point in my briefing and the summary judgment was the discovery didn't reveal anything in addition to what the court had in front of it when it granted the motion to reconsider in 2021. So in 2023, when the court entered the summary judgment, there was no additional information in the record about the category of fraud.
Well,
So-
counsel, let me ask you, what information was in the record at that point for the court to reconsider? I mean, while it was called an ex parte hearing from 2020, Mr. Jefferson was there and there was evidence put in and a finding was made on that. Granted, it wasn't challenged. It seemed to me what the court was really trying to do was provide due process to your client, and it went from there. And I just don't see any reasoning anywhere to support one way or the other outside of all the way back in 2020.
Well, Your Honor, if you look at the items in the record, the motion to reconsider and then accompanying, there was a motion to dismiss or an alternative for summary judgment. There was 105 pages of exhibits, which were all of the notes that were taken by the settlement agent that in the process of closing the loan, which.
But an aspect of the question, so you're answering an aspect of the question, which is what other information might have been available. But an aspect of the question that was troubling me is the original ruling was this transaction was void. And then the ruling granting reconsideration to me is a little bit murky, but reading it in your favor as a determination that, okay, I'm changing my mind, I think it is now voidable. Where does the trial court explain any reason for changing its mind? And here is why I'm now concluding it's voidable. What is the trial court's reasoning for changing that?
Well, Your Honor, the briefing before.
I'm just asking what the trial court stated reasoning was. Is there any, leave aside what what information might have been available to inform the trial court's reasoning, but does the trial court ever say, here is my substantive reason for changing my earlier ruling that this was void into a ruling that it's voidable?
Your Honor, I think it was, you would probably have to say it was implicit in the fact that the information the trial court had fully briefed from both sides. So it had all the cases that the trial later relied upon in granting the motion for summary judgment. And the cases.
And I mean, Judge Howard's question raises another thing that could have been implicit rather than I'm substantively changing my mind. I want to afford, a fair process to a party that didn't have an opportunity to litigate that question and is now coming in and trying to litigate it. That would be another implicit explanation. How should we be confident that one of those implicit explanations is the right one rather than the other?
Your Honor, I think it's because, as your honors are very well aware, there's just a fundamental distinction between fraud in the factum and fraud in the inducement. And the case law, as I read it, is clear, and this was given to the trial court at both the motion for reconsideration and at the motion for summary judgment, is that a forged deed is going to be void ab initio, regardless of whether someone who buys the property later is a bona fide purchaser because it wasn't effective to transfer the property. In this case, at the February 2020 hearing, Mrs. Smith testified, and this is in the record, testified that she did sign that deed.
Yeah, but that's definitely not what the statute says, though. I mean, we've codified UCC 3305. What it says, it refers to fraud that induced the obliger to sign the instrument. This is apart from forgery. The obliger signed the instrument with neither knowledge nor reasonable opportunity to learn of its character, which, I didn't know it was a deed is one way you want to know if it was of its character. That doesn't apply here. Or its essential terms. That is, I don't understand why she doesn't have a pretty good leg to stand on that I was unaware of its essential terms. I thought I was signing it over to a company that I was at the head of, and then really over to me as, why isn't that under the plain statutory language, or at least a question for the jury of whether or not she was aware of that essential term?
The statute, Your Honor, you're relying on is in
283305?
So that's the negotiable instrument statute, Your Honor.
Well, we could also rely on Moore v. Deutsche Bank, our 2015 case that Judge Thompson wrote, which says essentially the same thing. Fraud in the factum is the sort of fraud that procures a party signature to an instrument without knowledge of its true nature or contents, right?
Then I do understand, Your Honor. I was just, I wasn't familiar with either of those because they weren't in the briefings, I don't think. But I do understand that. What I think though is that there's a difference between the Smith's attorneys dismissed my reliance upon the Scotch bonnet case out of Maryland. But that's where I think the court wrote a very well-reasoned opinion that explained, because that was a case where articles of incorporation of a corporation that owned property were forged, submitted to the state, approved by the state, and therefore the forger was able to convey property for value to a third person. Then the corporation comes back and says, well, that person wasn't authorized. And the court held that's fraud in the inducement. That's not fraud in the factum. And therefore the deed was not void, it was voidable, and therefore a bona fide purchaser that paid value for it was protected.
Can I just ask, if we're asked, if the right question is whether or not they were aware of the essential terms of the contract. Now, let's just make a simple example. I think I'm the Queen of France. And I think I'm the Queen of France. I'm confused, but that's what I think. And let's say I have some defrauders who held a coronation ceremony for me and everything. And then I sign over my property to, the French royalty in care of the Queen of France. Would you say when that I was aware of the essential terms of that document?
That might be more of an incompetence kind of question, though, Your Honor.
All right, well, I mean,
I think-
let's make it slightly less ridiculous.
Yeah.
Let's say I think, somebody holds a faux ceremony for me, declaring me the ANC chairman for wherever I live in DC. And I believe I'm the ANC chairman and I bequeath my property to chairman of the ANC during this period. Perfectly mentally competent, I just got duped. Would I have knowledge of the essential terms of what I just signed? I mean, it seems very much like this case, and it doesn't strike me as an easy answer. It doesn't strike me as an answer we could say as a matter of law.
Your Honor, I think if anything had been submitted in opposition to my statement of undisputed facts in support of the summary judgment that showed that Smith didn't understand what she was doing, but all she ever contended was they promised me to make me a member of an LLC and I wasn't one. And that was based solely upon the articles of organization that were submitted to the state of North Carolina that didn't list her as a member. But I think Your Honors know this. You don't have to list the members. It was on an optional section of it. I'm not sure, Your Honor, that this really was a foreclosure rescue scam. Even though the other side says that there was no consideration, the consideration was all of Smith's debts, which she was getting foreclosed on for not paying.
Well,
were
counsel,
getting
if you're
paid.
not sure, doesn't that sure start to sound like a fact question?
I'm sorry, Your Honor.
If you're not sure, counsel, doesn't that sure start to sound like a fact question that would be inappropriate for summary judgment? It sounds like there's still some things to sort out here.
I think, Your Honor, if the other side had asserted that in their statement of disputed facts in opposition to the summary judgment, that might mean that the court, would have to say, it has to be undisputed or I'm not going to rule on summary judgment. I'm going to have a trial. I think that the judge was not given an opportunity to do that because of the third-party plaintiff's failure to make that assertion in their statement of undisputed facts.
Is that also your reaction to appellant's point? What about the addendum to the deed that never got recorded with it? If I remind, is it that, well, they didn't raise that earlier or that's irrelevant for some reason that I'm not thinking of?
Your Honor, I'm not sure there was ever an assertion by Mrs. Smith that the addendum was supposed to be recorded with the deed. I also not sure that it was that it would limit the unqualified transfer of title in the deed.
Why wouldn't it? I mean, that's a question of interpreting the deed. And if the deed, part of the deed says A is giving this to B and part of the deed says, oh, by the way, I'm A and I think I still own it.
But
Then, it seems like that's arguably an internally inconsistent deed. Now, maybe that might be different from fraud and factum. That might be a question of how to interpret the deed, but isn't it, it's a puzzling deed where summarizing, it seems that part of it, as you say, seems to be an unqualified transfer of the property from A to B, But another part of it seems to be saying, by the way, to be clear, I continue to own the property.
Your Honor, what I would say in response to that is her assertion that she was going to remain an owner of the property was as a member of the LLC, not that she was going to be the fee simple owner of the property.
That doesn't seem clear on the face of the addendum, and that the addendum was certainly taken into evidence in the 2020 hearing. And so, I mean, it doesn't seem to me much of an issue whether she asserted or not. It was there and it was in evidence. So how is it that with these conflicting things, we say that she understood it all? And really, I guess your answer may be it's her burden to prove that, not yours.
Well, definitely, the burden of proof was to show definitely on Mrs. Smith to show that we're not bona fide purchasers. I think that the burden of proof on summary judgment was for her to raise a disputed fact that contradicted the statement of facts that my client entered into. But I do understand Your Honor's point.
Can I ask if the addendum is a way of distinguishing Scotch Bonnet in the sense that the addendum here is part of the deed? Or do you agree with it? That's a fair way of describing it? Or do you think it was more tightly associated to the deed, let's say, than a distinct articles of incorporation somewhere?
Your Honor, I
mean, again, by
I don't have
allegation,
it in front of me.
and this is what's alleged, I understand.
I
So
admit I
taking-
don't have it in front of me. I thought it was an addendum to the contract. And I know when I do
Oh.
deeds, I don't record the contract with the
So
deed.
It was signed January 2018, so that would make sense. I mean, it wasn't signed at the same time as the deed, right?
Exactly, Your Honor. Thank you for adding that. Just before I run out of time, the one thing I wanted to say was that when we talked about the effective date of the deed in response to the DC statute that my worthy opponent cites, the next section, in other words, it says where they say you got to record your deed within 30 days. The next section of DC code 47-1433 states in paragraph C, if a person fails to record the deed or other document as required by 47-1431, there shall be imposed on the person an additional penalty in the amount of $250. Period. The penalty provided herein shall not be imposed if the deed or other document is a security instrument. So I think that's a red herring. I think that statute, even though you all understood my argument about a justum generis, that those others interested in the property probably are limited to people who paid value for the property in between when the deed was signed and when it was recorded, and which I think is correct. I think that the statute's just a red herring. It's a way of, penalizing people $250 who fail to record their deeds in 30 days. Doesn't render the deed ineffective.
Can I ask, we haven't really talked about summary judgment on the bona fide purchaser aspect of this. And I'm inclined to think, I don't underwrite loans for a living. Neither did the trial judge. But you've got an expert saying, if you're underwriting loans, this is her expert, was it Smith? If you're
Stephen Sushner was the expert for Smith.
right. If you're underwriting loans, here's 8 red flags. These things should prompt you to go look further, and you would have figured this out. I find it very hard to say outrageous. There's no way that's right. No jury could believe that expert. How did do you want to defend the trial court getting
Yes,
there?
Yes, I do, Your Honor.
Uh-huh.
There was another expert that I called who provided his opinion to the trial judge that I think the trial judge relied upon in saying that the things that Mr. Sushner, the Mrs. Smith's expert, said, because he didn't really claim any one of them were red flags. He just said if you took them all together, they were red flags. But I think that the cases cited in my appellee's brief show that continued occupancy of a property and use of quitclaim deeds those are now disfavored reasons for denying bona fide
You mean
purchaser status.
by themselves inadequate, or you mean they're not even appropriately considered as in combination with other things, part of an overall red
I
flag?
think that's what my expert's rebuttal
Well,
said.
again,
What-
if one expert says one thing and another says another, a lot of times that means a trial is needed rather than that a trial judge should figure out which expert the trial judge finds more persuasive.
No, and your honor is spot on. It's just when one expert, Mr. Sushner, as in my expert's rebuttal points out, gives wrong dates, gives wrong information all through his opinion. I don't think it was a reasoned expert witness opinion. And the judge did say that the factors that Mr. Sushner relied upon in saying that intervener was not a bona fide purchaser occurred after the fraud was discovered.
Do you know which? So I'm just looking at the expert report. I've got the eight reasons that Schuster lists. The only recollection I have from the trial court's grant of summary judgment is those were, and this is at page 1 and 2 of the report. I believe they're repeated in the rebuttal report at page 2 and 3. The trial court says, well, some of those came up after the purchase. Didn't explain which, didn't explain why they would have mattered, why the standalone, why the ones that didn't, wouldn't standalone be enough to get to a jury. So which ones of these 8 only came to, which of these 8 red flags, quote unquote, only would have come to light post closing? Post, what is it, October 8th?
Well, Your Honor, that's what I was putting in artfully was, I don't think that those pre-closing red flags were really red flags. They were things like, quitclaim deed, use of quitclaim deeds, not getting title insurance for the transaction between.
Yeah, like I said, I don't underwrite loans. I mean, you're talking to the wrong guy if you want me to figure that out. What we usually do is you usually have experts get up and talk about that, and juries figure out which one they find more persuasive. Why is a trial court in a position to say, no, these 8 things I know better than the expert? I mean, he could say the expert's not qualified, but he didn't say that. He could say, there are some cases, an expert doesn't automatically get you to a trial. Sometimes it's so unreasoned and so clearly slanted that you could say nobody would believe this expert. The trial court didn't really say that though either. What the trial court said was some of these things came up too late. And I couldn't figure out which of those 8 things that was true of.
Well, Your Honor, I think what I would focus on was the fact that the Mrs. Smith's own arguments always said the intervener became aware of the fact that Mrs. Smith was claiming that she was defrauded of selling the property on October 17th, just days after the closing.
Right.
And I think this goes right to what Your Honor was focusing on earlier about the effective date, is that the horse was out of the barn on October 10th.
Yeah, but we're talking about inquiry notice here. We're not talking about being aware. We're talking about inquiry notice of did you have enough warning to go investigate more than you did? And would that have turned up evidence of the fraud? And I don't think there's ever been disputed that the second half of that is satisfied. They could have discovered this fraud through a simple phone call to Miss Smith, I think. So it's just the first part. Were these 8 red flags enough to inquire further? An expert says yes. And what? I'm supposed to say, as a matter of law, no, because of my expertise in underwriting?
Your Honor, I'm not sure hiring an expert to say something always means you get a jury trial.
For sure. I just don't know what basis. I just don't know why this one wasn't enough.
I think it's because the things that happened before the closings could all be, they didn't, I don't think they constituted inquiry notice into some kind of a fraudulent transaction, because they were things like the loans weren't paid off back when Smith conveyed the property to SJNF in February. Of course they weren't. The SJNF took the property subject to those loans, and then with Mrs. Smith's participation, obtained the payoffs during the summer of 2018. And then the payoffs were paid by my client on October 10th, 2018. So I don't think that, and the discontinued occupancy of the premises and the use of a quitclaim deed, there's just case law explaining that those things are not really red flags. So I think the trial judge could conclude that the expert testimony of Stephen Sushner was incredible, and my expert
But you would
witness-
agree that any credibility finding like that is at best implied, like we'd have to fill in the blanks.
Well, I don't know if it's credibility or just it's not really sufficient expert testimony, Your Honor. That's what I think.
Did the
is.
judge say anything beyond, oh, this notice looks gray, not red? Well, it didn't even say the not red, just the notice looks gray.
He used the terms while intervener could have done a better job if it was like superhuman or whatever, but it's just like it didn't have to do any more than it did. And I think Your Honor recognizes these transactions are conducted by settlement agents for the lenders. It's not like the lender was day-to-day involved in obtaining payoffs and things like that. And all you can see from the notes of the settlement agent, which are in the record, are the lenders complaining, why is this taking so long? But it's not like the lender is being confronted with, we think there's a problem. It was only on October 17th when my colleague's client Rushmore said Smith's, claiming fraud. The first entry into the foreclosure file docket about any type of claim of fraud is October 17th. So, but Your Honor, those are the best answers that I can give. I've taken up too much of my colleague's time. If I can yield to y'all, Rushmore's client, if you all don't have any more questions.
Thank you, counsel. We'll hear now from Mr. Stewart.
May it please the court. My name is George Stewart. I represent Celine Finance, successor in interest to Rushmore. I'll be brief. There are two orders on the motions for summary judgment. The first order dealt with Rushmore's foreclosure on the original mortgage, which led to kind of this other dispute, which is what you've heard today in court, which is the second issue between Wilmington and Ms. Smith regarding whether the deed was voidable and the notice. We simply just asked that the issues in the original foreclosure suit are not for the court today. Those haven't been briefed by the parties. They haven't been argued before you today. We just asked that the original foreclosure order be held valid and affirmed with the from the Superior Court. If there are no other questions, thank you.
Thank you, counsel. Hear now from Mr. Landers in rebuttal. I believe you reserve 4 minutes.
Thank you, Your Honor. That's right. Thomas Landers, pro bono counsel for appellant. I do have a couple points, unless the court has any questions at this time.
I have a preliminary one. Could you address what you just heard from Rushmore Celine? Is there any issue, or is that a point you're ready to concede that you're not contesting that order?
We do not contest the part of the order that counsel spoke about.
Okay, thank you.
Yes. So first, very quickly on the addendum that came up during argument earlier. I think Judge Howard pointed out that it was in the record, and I would also point not only to Appendix 444, which is the addendum itself, but also in the statement of facts, the Ms. Smith's statement of facts on summary judgment, and Appendix 430, the January 9th addendum, the relevant one, is at paragraph 7. So it was clearly before the judge on summary judgment. So my second.
Well, I thought their answer to that wasn't part of the deed. That was part of the contract. It was signed 9 months earlier. So, she wouldn't have thought it. So the deed itself made no reference to that addendum. So she understood the nature of what she signed, and, she wasn't careful enough about saying, I'm still the owner of this C addendum.
It's true that the deed itself on its face does not mention the addendum, but I think it is a tribal issue of fact whether the transaction between Ms. Smith and Jefferson included the addendum as an essential element and her ongoing ownership of the home.
And how do you distinguish the Scotch bonnet case on which your opponent relies?
Well, in Maryland, Scotch bonnet stands for the idea or illustrates the idea that under Maryland law, a forgery is critical in order to have fraud in the factum. But in DC, that's simply not the case. It goes to the character or essential term that Judge Deal was talking about. That is one of the key elements of fraud in the factum in the district.
And you would agree that fraud in the factum in the district, it has an extraordinarily high bar to reach, wouldn't you?
Well, there is case law that says that. That's true, Your Honor. I think even if the court does not rule as a matter of law that there was fraud in the factum, which we do think is the case, but even if the court doesn't go that far, I think the earlier colloquy here did speak to the idea that it is a jury question. What, like I just said, what Ms. Smith believed the transaction to be, and her understanding of what the deal was.
And is it right to say that the reason you think it's fraud in the factum is because she didn't understand who she was selling it to, because she was and the consequences of that, because she thought she was selling it to an entity that she was a part of, and therefore it was like a transaction to herself. And in fact, it was a transaction to an entity that turned out to be entirely unrelated to her. Is that, in a nutshell, what you think is the fraud in the factum?
Yeah, that's in a nutshell. And I've been saying she didn't understand, but of course, the key idea is that Mr. Jefferson misrepresented that to her and misrepresented an essential term, maybe not the character of the instrument, but certainly an essential term of who the grantee was and whether she would continue owning the house, which she believed she would. So my other point was about inquiry notice, and there are cases that do find or rule that inquiry notice happened, you know, that the lender or the purchaser was on inquiry notice based on certain red flags. And we do think there are more than enough red flags in this case. I think in order to rule as a matter of law that there was inquiry notice, the case law.
I'm sorry, did you just say that you think we should rule as a matter of law that there was inquiry notice, or that we should reverse the trial court's grant of summary judgment on the theory that as a matter of law there was not inquiry notice?
So it would certainly be going farther to say that there was inquiry notice as a matter of law. I think our main point is that taking all reasonable inferences in Ms. Smith's favor, Wilmington has not shown as a matter of law that there was not inquiry notice. That's our main point. And so that's why the summary judgment should be reversed and remanded. The number, I have not seen a case where there's this many red flags and the court ruled that there was not inquiry notice. I just haven't seen a case like that. I think reversing summary judgment here would be well within the precedent of other case law that we cited in the briefs. And I would point to one quick factual thing is that Counsel for Wilmington just said that the lender, Vizio, was not day-to-day involved. This is not a crucial point, but I would say that the loan file certainly does show that Vizio's staff were day-to-day involved with ServiceLink, its settlement agent. So Vizio was well aware of what was going on. They were continually monitoring what was happening. And one point that came up briefly earlier that Counsel for Wilmington mentioned was continued possession, and I believe counsel referred to it as not giving rise to inquiry notice. But the case law on continued possession of the prior owner, that comes up often in these inquiry notice cases. And it is, so in general, the idea is that if somebody's still living there, common sense dictates that this potential purchaser or lender should ask, what are this person's interests? In fact, there is case law, and the Powell Treatise that we cite says that potential purchasers have a duty to ask, in landlord-tenant cases in particular, a tenant who's still there about their possessory rights and their tenancy rights. So so there's that, but I recognize there is an exception also in the case law where you have a seller. And in this case, Vizio did believe or was told that the seller, Ms. Smith, the seller was the person who stayed in the house. And there is case law that says that a seller who stays for a time in the house is not necessarily a red flag, but this for a time thing is important. And well, it could be important. There is case law that just doesn't really address this exception out of jurisdiction, but at least in the district, I think it's a difficult issue of how much time matters. And I think that's another one of many reasons to reverse summary judgment is the fact that she stayed in the house for 6 months, you know, and she was the seller, but she stayed there for 6 months. And it does that, our position is that does give rise to that her ongoing possession should be seen as a red flag, even though she was the seller, but she kept staying there. And so I still think that should be considered a red flag. And compared to other cases, the 6 months is in line with some of the other cases that we cited where the courts did find that there was inquiry notice. In the Martinez case, I believe the ongoing possession was about 7 months. Again, that was the seller. And in another case, we cite Harid Zak out of Texas. In that case, the sellers kept possession for about 9 months. So I think the 6 months is not a deal breaker here. I still think that her ongoing possession is meaningful and it is a red flag. And there's other, I hear that Judge Deal was saying how, in terms of there are tribal issues of fact here as well, that would be another reason to reverse summary judgment. Though I did hear Judge Deal say that it should not, there was no dispute about how if Vizio had called Ms. Smith, they would have definitely found out. I do think that's the case. But that could potentially be another tribal issue of fact, but more importantly, it was Vizio's awareness of Ms. Smith's possession. That could be tribal issue of fact, is how aware was Vizio of her living there. We do think they were aware because there was an appraisal that was done that's mentioned in the loan file. And then there's this question of this lease to someone named Moses Purnell. There's no indication that Vizio took any action to reconcile the lease with her ongoing possession, but that could also be a tribal issue of fact that the court below did not explore at all. That's certainly a glaring discrepancy to have this lease with someone else named, but Ms. Smith living there. So it's a red flag, and there's just nothing below about Vizio looking into it. So we do ask that this court reverse summary judgment, and because Wilmington has not shown as a matter of law that it lacked notice, and because of tribal issues of fact on the inquiry notice issue.
Thank you, counsel. We will take the case as submitted and we will now stand in recess.
All right.